You can have them re-enter the same one. Yeah, have them re-enter the same one. The one that I sent them on the text earlier. Sorry about the interruption in the video. There has been a problem with the Zoom recognizing that we're Zoom for government now and not just ordinary Zoom. That's why we timed out. So we will, as soon as we can, get the courtroom back.
Seated and obtaining a change of positions. And the compensation judge found that $1,900 was a reasonable attorney fee. However, the compensation judge awarded $500 because they felt that that was the maximum they could award
Mr.
per
Rowland, we're at
statute.
the 3-minute mark, so I'm going to interrupt you to
Sure.
see if if anyone has any questions.
I have just a housekeeping question to start. The employee, Parker Stevens, male or female?
Male.
Okay, because I saw referenced a female pronoun in one of the briefs and a male pronoun in another brief. I don't remember which one, and I just wanted to be sure. Okay, thank you. The Wesley case that you cite, if I remember the Wesley case, and I've got it here, but I'm not reading it at the moment, there was actually an attorney fee hearing. And so consequently, this court said, well, all of the Irwin factors really weren't discussed at the hearing except for the one, something like that. At least there wasn't evidence of the other Irwin factors except the one that the comp judge decided. And of course, now we have Jurgensen. And again, admittedly, Jurgensen happened after the comp judge awarded you the fee in this case. So she didn't have the benefit of that decision in front of her. But it seems like Jurgensen, it didn't say a comp judge must go through every single factor, but it did say that's best practice. And we don't have that here. Shouldn't a compensation judge go through the factors? I mean, you seem to say we have to assume it based upon the one finding that she had. So talk about that.
Yes. So in this particular factual situation, it would be a waste of judicial resources to belabor the point with specific findings when both parties agree and the judge agreed that it was pursuant to the appropriate law. Now, as far as Jurgensen goes, again, that's distinct as mentioned before because both parties and the judge, in our case, agreed on the fee. In that case, clearly they did not, and that's why it made its way up to the court. And there were other factors involving the time for the petitioner's attorney, et cetera, that led to ultimately that fee not being appropriate. Now, as far as what I'd consider the dicta about an Irwin analysis in Jurgensen, Jurgensen did say that it was best practice to go through the Irwin factors, and I have no dispute to that. That was what it said. But it also fell short of creating a bright line rule and requiring that it to be the case. So while it be best practice, it certainly isn't required. And there was also language in Jurgensen that said, we've never required an analysis of every Irwin factor. So while I would agree that in many cases that may be appropriate, this is certainly one of those cases where it's not, because of the agreement between the parties and the judge pursuant to statute. And ultimately, from a practical standpoint, this would change a lot of workers' comp if the employer insurer's position was adopted in this case.
Well, but you don't dispute that the employer insurer had the right to appeal that order of the attorney fees to this court.
Correct.
All right.
Yes, either party could appeal the order. I agree.
Okay, so now we have it on appeal. How do we review the Irwin factors if and the judge's findings on the Irwin factors if we really don't have any?
Just as courts have done it in the past when there was not an explicit review of the Irwin factors. In those situations, there's all different cases. There's some that didn't review the Irwin factors at all. There's some that maybe reviewed 2 of the factors. And in all of those cases, the courts applied a hang a mule analysis. They did look at if the court reviewed any Irwin factors, the court reviewed that on appeal. If they didn't, they reviewed the entire record as submitted for the 7 Irwin factors.
So, Mr. Rowland, I want to kind of get back to the standard of review because you're saying that we should be looking at the evidence. Do you agree that there are no undisputed facts here?
As far as the merits of the case, I would agree there's no undisputed facts. That's correct.
Okay. So, and what Judge Quinn was saying is it's hard for us to review factual findings when there really are no factual findings. This is an award of fees where Irwin is cited, but the Irwin the compensation judge, again, did not show her work. We don't know what her analysis was. Just because she cited Irwin doesn't mean that she actually went through the analysis in her mind or anywhere else. When you look at the order, it's hard for us to know if she just agreed to it because there was no objection. And so I look at it as this is the application of law to undisputed facts, and it would not be a hang-a-muley standard. Do you agree with that there are no undisputed facts here?
I agree that the facts on the merits are not disputed, but not in the same way that you phrased it. I believe there were sufficient factual findings in the record to support it under these circumstances. The judge reviewed the appropriate law, cited the appropriate Roraff and Irwin cases where the 7-factor Irwin.
So, but you're asking us to assume that just because Irwin was cited, that the analysis was conducted by the compensation judge. That's a pretty big leap, don't you think? And don't you think that Jurgensen and Irwin require more than just a citation of the case?
Jurgensen suggests that it's best practice to have more than a citation of the case. I would agree with that. However, it didn't require it. And it would revert back to other case law where there wasn't an explicit finding of all 7 Irwin factors, where the Court of Appeals then looked at the record to see if Irwin was supported, notwithstanding that the compensation judge did not review them entirely.
And again, it makes it very difficult for us, though, to try to assume or imply what the compensation judge was analyzing or concluded without her showing her work. Correct? It makes our job much more difficult, and the Supreme Court, if it were to go up, to understand exactly what the compensation judge was analyzing or concluding.
I would agree that the more thorough the record, the easier the case would be for an appellate court on review. But ultimately, that doesn't change my position on the argument. I agree that the record was relatively brief here, but it was sufficient based on our our situation in this particular case.
Do you agree that a failing to object to the statement of attorney's fees does not relieve the compensation judge of her obligation to review an excess fee under Irwin?
Yes, I agree it does not relieve the obligation, but it'd be in the same way as in a stipulation for settlement. So let's look at the hypothetical. Let's say there's a settlement for $150,000, and let's assume it's under the old fee cap of 26, but the petitioner's attorney is asserting $30,000 in fees. So it would trigger an Irwin analysis. Now, in that Typical situation, the parties would agree on the fee, it gets submitted to the court, and it's subject to judicial review. And the judge must review the full record and determine if that 30,000, which part of it would trigger Irwin, is consistent with the law. In situations like that, I've never seen a compensation judge make explicit findings of all 7 Irwin factors because it's not disputed. Now, the compensation judge certainly can and should review it to be consistent with the law, but that's exactly what happened here.
But isn't Jurgensen saying that the work should be shown?
Jurgensen is saying it's best practice to show the work, yes, but it did not create a bright line rule. And Jurgensen certainly wouldn't have been contemplating our specific situation where neither party nor the judge disputed the reasonable attorney fee. That was a very factually distinct case where the judge didn't find it appropriate and had good reason under the law not to find it appropriate for those specific facts. Those are not the facts in front of us today.
Okay, let me ask another question. It'll be a little tighter than my other question. So if we were to vacate, it would only be vacating order 1, which is the award, because I don't think we would need to vacate orders 2, shall not pay, basically the employer is going to pay the fee and or the cost, because I think we have agreement that the costs and the employer are going to pay it would just be 1, and then refer it down for simple, quick findings by the compensation judge per the Irwin factors, and have a decision that way, as opposed to having a full-blown hearing because there was no objection. Is it, and given that, did the employer and churches, is it a waiver, or did they just fail to object in terms of this whole dispute over what you should be paid as attorney fees in this case, Mr. Rowland?
Yeah, so if this case were to go back down under any type of terminology from this court, there absolutely should not be an attorney fee hearing. The record is closed, the record is in, and to the degree the court feels that there's more findings needed, the judge can review the record on the closed findings based on what is before the judge currently. Yeah, ultimately, if we were to allow the case to be opened back up, it is what I can't remember. One of the judges mentioned that it would be kind of like a second bite of the apple for the employer insurer when there was no dispute in the first place. I see my time is almost up. There was just one more case that I wanted to mention, Muhammad v. Turkey Store and Wausau. So that was one where the compensation judge felt that $1,900 was a reasonable fee, but only awarded $500 based on a statutory rule. It went up on appeal, and ultimately the Court of Appeals vacated the $500, awarded the $1,900, even though the compensation judge didn't go through any type of Irwin analysis. They purely adopted the reasonable attorney fee that was decided by the compensation judge, and it's because their logic was both parties agreed that it was a reasonable attorney fee at the attorney fee hearing. And even though it said it's generally best practice or language along those lines to document the Irwin factors, they said it would be a waste of time to put everyone through that, given that there was no dispute on the particular attorney fee. And ultimately, that $1,900 was awarded, even though there was no Irwin analysis, explicit or implicit.
Counsel, I know there's just, I have Mohammed in front of me, and this court in Mohammed actually said, because the compensation judge did not make specific findings for each of the factors, we would normally be inclined to remand the matter. In this case, however, because at oral argument, the hearing before this court, the parties agreed that $1,900 was reasonable, we see no reason to delay. So I read Mohammed differently. It's without specific findings, we would remand. So, but you have a different interpretation of Mohammed?
My interpretation is that the parties agreed that the $1,900 was reasonable, which is analogous to this case. No objection means that the parties were agreeable on the claimed attorney fee. And ultimately, it was not remanded because of that agreement, even though there was no finding of the Irwin factors. The WCCA did not require the judge to show their work because there was agreement by the parties at the lower court here.
I see what you're saying. Thank you.
I see my time is up. Thank you.
Thank you. Thank you both for your respective presentations. The record is now closed and we will issue a decision within 90 days of today's date. Thank you. Guys. Court is adjourned.